everyone, welcome to the HR Legal Lowdown. Today I'm joined by Georgie Chapman, partner at HR Legal, and today we are bursting open the most common workplace myths that often trip up employers and see them in front of the Fair Work Commission. So, Georgie, thanks for joining me.
Thanks for having me, Alex.
Let's get stuck in. This should be fun. These myths seem small but can lead to serious issues if employers rely on them. Let's jump in. Myth 1, Georgie. 3 strikes and you're out.
This is an HR urban myth. We see this coming up many times. It's a common misconception. So often employers think they need to be able to provide 3 warnings before someone can be dismissed. And certainly that's not a legal requirement if we're considering the risk of an unfair dismissal claim. We want to be able to give employees who aren't meeting expectations around performance an opportunity to improve. That helps to reduce the risk of a successful unfair dismissal claim. But certainly if someone hasn't been meeting conduct expectations and the like, it doesn't have to be 3 strikes and then you're out, unless you have a policy in place or something in an enterprise agreement that requires you to do so. And of course, as is always the case, you can dismiss someone any day of the week. It just depends on your appetite for legal risk. So if you're unsure, always worth getting advice.
Well, there we go. Myth 1, busted. So that means depending on the facts or the level of misconduct, sometimes no warning is necessary.
Correct.
Good to know. Myth number 2, independent contractors aren't entitled to minimum pay.
Well, as lawyers love to say, it depends. Generally speaking, the premise is if someone is genuinely engaged as an independent contractor, they don't receive the same sort of benefits under the Fair Work Act, such as different types of leave and paying conditions. However, often we see the relationship mischaracterised as an independent contracting relationship when it should actually be one of employer and employee. Mm-hmm. And so really what we need to look at now is the totality of the relationship. There's been some legislative change and the Fair Work Act now has a definition of employee, and it's not really just down to what the contract says or what the parties have called the relationship. It's actually what the relationship is in practice.
Well, the High Court has slogged this out recently, but there is a famous quote that is relied on often. It's something about chickens and ducks, Georgie. What's that?
Ducks and roosters.
Ducks and roosters.
Yeah, we can't expect that everyone refers to something as a duck, even though it has all of the aspects of a rooster, and insist everyone recognises it as a duck.
Well, I do like that. And I must say it's always good to have farmyard animals in a conversation like this.
Very helpful.
Very helpful.
Yeah, very legally technical.
Yeah, love it. So myth number 3, surely this one must be true. You can dismiss anyone during the probationary period without risk.
Well, incorrect, once again. So while someone who hasn't completed a minimum period of employment is not protected from unfair dismissal, and that's 6 months if they have employees of 15 or more, or less than 15 employees, it's 12 months. However, if someone is not protected from unfair dismissal, they can still make what's known as a general protections claim to the Fair Work Commission, irrespective of how long they've been with the employer, or they could make a discrimination claim under state or federal law.
Well, that's 3 myths and they're all busted. So that's 3 strikes for me. What does that mean, Georgie?
You're out of here.
Well, on that note, I thank you for your time, Georgie. This has been the HR Legal Lowdown. We hope you've enjoyed the session and please don't hesitate to follow along or suggest any topics you'd like to see us cover. Thank you for listening.
Thank you.